Ms. Gonzalez, do you mind calling?
Yeah, I'll do that right now.
Oh, there he is.
There we go. Okay. The court calls cause number 323-114-268-20. This is styled the matter of Braden Marquise Hood. We're here for an adjudication hearing. The court will take notice that there was a petition filed alleging the delinquent conduct of the child filed on August 10th of 2020, that there was a grand jury approval for determinate sentencing punishment signed by the judge of the 372nd District Court on August 18th, 2020, that there was that the child was served with determinate sentence notification on August 24th of 2020. I do not see that a return that the mother was served. However, the court will take notice that the mother, Ms. Sparkle McGilvery, is here present via Zoom. We are conducting these proceedings remotely through Zoom in compliance with the Texas Supreme Court Emergency Order number 25. All right, so Mr. Hood and Ms. McGilvery, if you can both raise your right hands for me. Do each of you solemnly swear the testimony you're about to give at this cause currently at trial, that you'll tell the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Ms. McGilvery?
Yes.
All right, thank you. You may lower your hands. All right, Mr. Hood, can you tell me what your full legal name is and your date of birth?
Braden Marquise Hood. My birthday is 11/21/03.
All right. And are you an American citizen?
Yes, sir.
So I want to go over a couple of things with you. I want to let you know that you are looking at a determinate sentence offense of aggravated robbery. That means you could do up to 40 years in TJJD and possibly transferred to the institutional division of the Texas Department of Criminal Justice for this offense. Do you understand what could happen?
Yes, sir.
That's not going to happen, but that's what could happen, right?
Yes, sir.
Okay. And you understand that if you do end up going to TJJD, that could be used against you in adult criminal proceedings. Do you understand that?
Yes, sir.
Okay. I want to make sure you understand you have the right to remain silent. You do not have to say anything at all. However, it's my understanding that you wish to give up that right, admit your responsibility in exchange for the deal that your attorney worked out. Do you understand that you don't have to say anything?
Yes, sir.
Okay. You also have a right to a trial. You have a right to have me listen to all the evidence that Ms. Smith puts up, and I get to decide whether or not you committed the aggravated robbery. What you were telling me is you do not need to have a trial, that you're willing to admit your responsibility to get the agreed punishment. Is that correct?
Yes, sir.
If you decide you do not like me, you have the right to have a jury make this decision. So 12 people would sit in the courtroom, hear the same evidence that I would hear, and they would decide whether or not you committed the aggravated robbery. But you do not need to have a jury make that decision. Is that correct?
Yes, sir.
Normally, you have a right to confront adverse witnesses. So that means the victim, the police, any witness that would come here and testify against you, you would have the right to look them in the eye while your attorney cross-examines them, and they get to decide how believable the witness is. Do you need to face your accusers, or are you okay going without them?
I'm okay going without them.
That's fine. Now, you also have a right to appeal on any case. However, there is a deal that your attorney worked out. If I follow this deal, you understand you cannot appeal this, that this will be final.
Yes, sir.
Finally, I need to let you know that I do not have to follow this agreement. Okay? The agreement is supposed to be 6 years commitment, probated over 6 years with a placement at Woodard Academy. However, if I say no to this, I will allow you to withdraw your plea of true, and your attorney can go back and renegotiate something else. I'm going to follow it. I just need to make sure you understand I do not have to follow it. You understand?
Yes, sir.
So that means if you start acting like a fool between now and then, that I can go ahead and reject all this, right?
Yes, sir.
Okay. All right, so Ms. McGilvery, I had previously sworn you in. Could you please tell us what your full legal name is?
Sparkle Renee McGilvery.
All right. And what is your relationship to Braden Marquise Hood?
I'm his mother.
All right. Thank you. Ms. Herrick, is there any reason why your client will not understand the proceedings today?
No, Your Honor.
Is he fit to proceed?
Yes.
Thank you. All right, Mr. Hood, we're here today because the state of Texas filed a petition alleging that you engaged in delinquent conduct, which, if committed by an adult, would constitute an offense against the laws of Texas, namely aggravated robbery. What they're saying is on or about July 24th in Tarrant County, Texas, that you intentionally or knowingly, while in the course of committing theft of property and with intent to obtain or maintain control of said property, you threatened or placed Talia Pryor in fear of imminent bodily injury or death, and that you used or exhibited a deadly weapon, namely a firearm. And that is a first-degree felony. Do you understand what they're saying that you did?
Yes, sir.
State waive opening.
It waives.
So what I have here, I'm sorry, any exhibits from the state? Court will take notice of file marked copies of the stipulation of evidence, a 3914 manifest, and a stipulation of evidence form. Any exhibits from the state for adjudication?
No, Your Honor.
Any exhibits from the respondent for adjudication?
No, Your Honor.
So, Mr. Hood, what I have here is a document that says stipulation of evidence. Do you recognize this document?
Yes, sir.
Did you go over this with your attorney?
Yes, sir.
On the second page here, there's a signature line. Do you recognize that signature?
Yes, sir.
Is that your signature?
Yes, sir.
So do you agree to everything in this stipulation of evidence?
Yes, sir.
Do you know what the term stipulation is? Have you heard that before?
No, sir.
Okay, that's fine. I didn't expect you to. So a stipulation is a fancy legal word. With that, it's a very formal way of saying agreement. So if I was to say that your mom's shirt on the screen was orange, is that something that you would agree with?
Yes, sir.
So we could stipulate, we will put in writing, we'd give in front of a judge, and the judge would say, I accept it. That means for the rest of time, you could be a 70-year-old man and you and I could not argue about what color her shirt was at 10 o'clock on October 28, 2020. Do you understand?
Yes, sir.
But if I was to say that your mom's sweater was yellow, is that something you could agree to?
No, sir.
You understand you could not stipulate this because you're 70 years old and we could be on her front porch yelling at each other about what color her sweater was on this date, right?
Yes, sir.
Do you understand how important a stipulation is? You could never disagree ever again, right?
Yes, sir.
So what I want to ask you is everything in this document you went over with your attorney, is it true or not true?
It's true.
Are you saying true because it is true and for no other reason?
Can you say it again, sir?
Yeah, did anybody force you to say true?
No, sir.
Anybody giving you cash money to say true?
No, sir.
Anybody threaten you or your family to say true?
No, sir.
Okay. Are you saying true voluntarily?
I'm saying true because it's true.
You're saying true because it's true. Thank you, sir. State waive closing?
Yes, Your Honor.
Oh, I'm sorry. One more question. Mr. Hood, in here, there's an allegation that you used a deadly weapon, okay, a firearm. Okay, is it true or not true that you used a deadly weapon during this offense?
It's true.
All right, thank you. All right, respondent waive close.
Yes, Your Honor.
Based on the competent evidence from this hearing, the court will make a finding of delinquency. Specifically, the court will find the allegations in paragraph 1 were established by the evidence. The court will also make an affirmative finding that a deadly weapon was used. That will conclude the adjudication portion of this matter. Ready for dispo?
It's ready.
Respondent's ready.
The court will call cause number 323-114-268-20. This is styled in the matter of Braden Marquise Hood. The court, having previously adjudicated this child delinquent of the offense of aggravated robbery and having made an affirmative finding of deadly weapon, we are now proceeding on disposition of this matter. Respondent or petitioner waive opening.
Yes, Your Honor.
Any exhibits from the state as to disposition? Now, the court will take notice of a social history that has been filed with the court under seal. But are there any exhibits from the state?
Your Honor, there are no further exhibits. I would like to briefly call the probation officers in this case.
Sure. And Ms. Gonzalez, if you could raise your right hand for me. You solemnly swear the testimony you're about to give at this cause permanent trial that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
All right, thank you. You may lower your hand. Ms. Smith, please proceed.
Thank you, Your Honor. Ms. Gonzalez, how are you employed?
I am currently a probation officer here with Tarrant County Juvenile Probation Department.
And Braden Hood, is he your client?
That is correct.
Okay. I just briefly want you to explain to the court how long Braden has been on probation for and the programming that he has done while he's been on probation.
Sure, absolutely. So looking back at our records, he's been on probation for practically almost a year. It'll be a year, November the 6th, so just next month. He's been under my supervision during this time, and we've offered several different programs, either based on referrals from the department or orders from the courts. He has one of the programs that he has participated in is function family therapy. It's my understanding that that outcome was failure to comply. He has also been placed on electronic monitor, and I believe that was twice, which were both completed successfully. He's also been ordered community service, and it's my understanding that that is currently still active. On his term that he was placed on for cause number 112653, there were 80 hours ordered, and I believe that there are 80 hours still remaining. And then on the cause number, the original probation, cause number 112019, he was also ordered 80 hours, and it's my understanding that 12 hours remain. He was also ordered initially to the drug court program through our department, and he completed that successfully. Mr. Braden was also placed at the Tarrant Youth Recovery Campus back in May of this year, and he completed that successfully on June this year as well. He has also been staffed with our department, and that took place back in September of this year as well. And the recommendation from the resource staffing is that he be placed rather than returned to the community.
How has he been in detention in the back?
We haven't had very many issues. He has fluctuated, it looks like, between level 1 outstanding and 2 acceptable. I'm sorry, 1 acceptable and 1 outstanding. Let me correct that. But I did see that this morning he has gone down to 2 acceptable. And it looks like the reasons for that was that he wasn't following instructions. And there was a mattress, I guess either set by the door, which would not allow officers to see his face. And apparently this is something that's happened 2 days in a row. So I'm not really sure exactly what all happened there. But like I said, overall, he's fluctuated from 1 acceptable, 1 outstanding, with very little, redirection.
Ultimately, do you agree with the recommendation put forth by the defense attorney and I for probation and placement at Woodward Academy?
I do. I think that's the best option for him right now.
I have no further questions.
Herrick, Cross?
How long has Braden been in detention?
Mr. Hood, I believe that, let me just make sure, because I know that the report on my social history was as of Monday. So he has been in our detention center for I apologize. Let me get that screen up right now. So for actual days, his stay has been 94 days, and then the length of stay is 66 days in our system.
So he's been in detention actually for more than 3 months at this point.
Correct.
And then other than, making his head not visible while he was sleeping, he's been doing very well in detention.
Yes, Ms. Herrick, that's correct.
And so just to clarify, your recommendation is that he be placed on a term of probation
That's correct.
and that he be placed at Woodward Academy.
Yes, that's correct.
And then when he completes Woodward Academy in, what do you think, like 6 months to a year, somewhere in there?
Yeah, I think you definitely did, come back and maybe engage in some type of aftercare plan to make sure that he is able to successfully complete. But yeah, I agree. I think he needs some time.
But when he's done at Woodward Academy, it's your recommendation that he return to his mother.
Yes, that's correct.
Your Honor, I really don't have any other questions. I'll pass.
Redirect.
And nothing further, Your Honor.
Any exhibits from the respondent?
No, Your Honor.
All right, closings or waive?
Yes.
Your Honor, I'll waive.
Eric?
Yes, I'll waive.
All right, thank you. The court, having reviewed the social history and considering all the evidence presented to the court, will make a finding that there's a need of rehabilitation and the protection of the public, as well as a child, requires disposition to be made. The court will honor the agreed disposition, commit this child to the Texas Juvenile Justice Department for a period of 6 years. However, the court will probate that sentence for a period of 6 years and require the child to successfully complete the program at Woodward Academy. Mr. Hood, I'm going to just say this man to man. Okay, we've met before, detention hearings, things like that, okay? You are right here on the edge, right? This is the moment. There's going to be a defining moment in your life, and I think this is going to be it. This is the date that I believe you are asking me to give you another chance. Is that fair to say?
Yes, sir.
You understand how I feel about guns and kids with guns, right?
Yes, sir.
There's no question about that one, right? Is there any misunderstanding of how important it is to me?
No, sir.
So you understand I'm very hesitant to give you probation. Like, my inclination is to send you to TJJD right now for, well, if it was my decision, it'd be up to 40 years. Do you understand?
Yes, sir.
Because you've had chances on probation in front of me, in front of Judge Nolan, right? And
Yes, sir.
you burned me on that one, right?
Yes, sir.
You understand you cannot burn me on this one. You understand how I feel about kids with guns and gun offenses. What I'm telling you right now is I'm giving you this chance because your attorney worked out this deal and convinced the district attorney to do so. So I will give you this chance. But you understand that when it comes to revoking your probation, if you mess up, you mess up, right?
Yes,
You
sir.
understand at this point, I think it's better to send you to TJJD. So if you mess up, if you skip school, if you get unsuccessfully discharged from Woodward Academy, if you're smoking weed, if you're showing up on Instagram with pictures of you and guns or cash or hanging out with people who are on probation, people who have pending cases, any of these things, right? Skipping school, running away from the house, walking on the home, like all these things, you understand all that is enough. Any one of those things is enough for me to send you to TJJD, right?
Yes, sir.
I'm kind of itching to send you to TJJD. That's what I want to do, but I'm giving you this chance. But this is you telling me that you are going to live your life 100% on the right side of things.
Yes, sir.
You sure you're going to do that?
Yes, sir.
Am I wasting my time?
No, sir.
So are you going to, but here's the thing. So if your mom tells you to do something and you don't do it, you understand that's disrespecting your mom, right?
Yes, sir.
How do you think I feel about kids disrespecting their moms?
You say how do I think you feel?
Yeah, how do you think I feel?
I feel like it make you mad.
It does, 100%. So what you're telling me is you are willing to give up the normal 17-year-old life in order to have a chance at not being in TJJD. You
Yes, sir.
understand? So your friend's going out hanging out in the corner. Can you do that or not?
No, sir.
All right. Your friend's playing around on the internet, getting involved in things that they shouldn't be. Can you do that or not?
No, sir.
Friends lighten up, Jewel, or whatever, right? Can you
Yes,
do that
sir.
or not?
No, sir.
What if it's just tobacco? Can you do that or not?
No, sir.
You understand? Your life is totally different. You cannot compare your life to the life of your friends and your peers. Do you understand?
Yes, sir.
The life that you're going to live is the life that your mom tells you to live. Do you understand that?
Yes, sir.
Every day when you wake up, you need to think, I'm waking up in my own bed, not at TJJD. And the only way I keep on waking up in my own bed the next day is you do everything 100% right. Right?
Yes, sir.
This is what you're asking me for. I'm not telling you, you're asking me for this, right?
Yes, sir.
You're saying, Judge, please give me the chance to live a very boring life, sitting at home watching TV and playing video games.
Yes, sir.
Okay. Now, attitude is everything, but Mr. Hood, I'm going to give you this chance, but as long as you're the one asking me for it, right?
Yes, sir.
Nobody's giving this to you. It's not a gift. You're asking for it and you're saying you're going to earn it, right?
Yes, sir.
Okay. I'll give you that chance. All right. But Mom, we're going to need your help on this one. All right. So don't think just because you messed up on something that it means automatically you can go to TJJD. What I'm saying is if your heart's in the right place and you make an honest mistake, I'm okay with that. We can get around that. I expect you to make a couple honest mistakes in there. But you know what? Smoking weed with your friends, that's not an honest mistake, right?
Yes, sir.
Walking out of the house, yelling at your mom, that's not an honest mistake, right?
Yes, sir.
All right. So, Braden, hopefully I won't see you again. I think I will, but if I do, it's okay. Just don't make big, you know what you need to live your life? You need to live your life as if the police or Judge Kim is standing right next to you for the next 6 years of your life. And you're going to say, would Judge Kim be okay with this?
Yes, sir.
Okay. Now, last thing I need to let you know is that you and I will see each other again. That's before your 19th birthday. I have to make a decision whether to transfer your probation to the adult court or to discharge your probation period. All right. So you've got almost 2 years. You know, actually, you have a little bit over 2 years to prove to me that I don't have to send you to adult probation.
Yes,
And I will honestly consider it. You've got a very serious offense, but if you turn your life around, I will cut you loose so you never have to go to adult probation.
yes,
But if
sir.
you're acting a fool and causing problems, guess what I'm going to do?
Send me to adult probation.
Now, you realize the adult judges, they're not as nice as me. If you think I'm tough, you got to see some of these adult judges, right? They don't fool around, right?
Yes.
I kind of let you kids, I give them extra chances because they're kids. Boy, howdy, when you're an adult, these judges don't mess. A lot of times you just, why don't you talk about Miss Smith's boss? You can show up 2 seconds late to court. You could show up with her calling your name, and because you weren't seated when she started calling your name, she'll put you in jail and revoke you. Right? That's how tough they can be downtown. I don't want you to go through that. Prove me right. Prove your attorney right. Prove the DA wrong. Right?
Yes, sir.
Make him proud by doing the right thing. Okay?
Yes, sir.
All right. Thank you, Mr. Hood. Ms. Gonzalez will go ahead and start because he's had some problems on EM before. I want EM on the first 30 days. Oh, no, he's going to Woodward directly, right?
Yes, Your Honor. So 2 things. We do need to have a detention hearing. And then because he's due for one today. And I do want to clarify for the record that Ms. Smith is waiving the misdemeanor charges attached to his petition and dismissing the violation of court order petition.
Is there a second amended petition then?
No, they're separate case numbers. I have the dismissal here. Yeah, so they're not attached to this case. I will be turning these in as soon as this court hearing is done. They're 2 separate cases.
All right, so then we have detention. All right, so
Yes.
Ms. Gonzalez, put a note, whenever it discharges from Woodward, we'll go and do EM for the first 30 days. All right, so Mr. Hood, you understand, we have a placement for you at Woodward Academy, right? It's already been found, but we can't send you there straight from the community. You have to be in detention for us to send you there because the whole COVID quarantine thing, right?
Yes, sir.
So you're a detentioner, you know you have the right to remain silent, you have a right to an attorney. If I hold you here, you have to see an attorney every 10 days. You remember this, all right? You understand I have to hold you. Because if I let you go, then you have to come here, sit here for 2 weeks just to go to Woodward Academy for the quarantine period. So I'm detaining you so you can get to Woodard. Go there, do the right thing.
Yes, sir.
Okay.
All right.
All right. Thank you, Mr. Hood. Thank you, Ms. Herrick. I've signed the voucher for you. And Ms. McGillivray, please let Ms. Gonzalez know once Braden comes back, right? We need your help. Like, I want to work together. Braden, I can tell he's respectful and you've done a good job with him. He's made some bad decisions. So let's just set him on the right path as he grows into an adult so he doesn't have to go, he doesn't go from that, school to prison pipeline. I don't want to see that for Braden. He's too good of a kid for that.
Okay.
Okay? All right. Thank you, everyone.
Thank
Thank you,
you.
Judge.
All right.
All right. So I'm leaving this Zoom session to go to the detention docket one.
Okay, may I be excused?
Yes. Have a good day,
Thank
Ms.
you.
Herrick.
You too.